Thank you all. Please be seated. This case presents so many questions that are not going to be answered in this courtroom today. It's difficult. This is a law school exam question with real life-changing effects, and so I don't minimize that when I say it's like a law school exam question, because it is. There are so many things here that, quite frankly, tip this decision both ways. I could rule in this case either way and support my decision, and by what I believe to be legitimate arguments as made by counsel, and looking at these statutes, which we can all agree are well-intentioned, but ambiguous, and when it comes to practically applying them, not very clear. And so this is a narrow look today. Let's be clear. Today, this issue that's before me today is not about proper supervision. It's not about the character of any of these three defendants who, has really taken a hit in this case over the last few weeks, and part of the reason why I let so much go on today, because I no doubt that to many extents, these three defendants are people who have worked with children and do a tremendous amount of good, and I don't want to disparage the importance of athletics and being on a team and all of that. And so none of that is really at play in this decision, and I just want to make that point. What we're looking at is very, very focused legal arguments. One argument is both in the motions to dismiss and then today too, is that you can't have sexual abuse when it's a juvenile or a child on a child. The facts of this case are such that I'm reminded of that judge, much smarter and accomplished than me, who said, maybe I can't define pornography, but I certainly know it when I see it. The ambiguous nature of that was highlighted in a 2013 Attorney General's opinion, which I know is not binding on this court. It's not binding. In that Attorney General opinion, the facts of that case was whether a child could commit sexual abuse on another child. In that case, it was even more extreme than that. It was the child herself who reportedly was self-exploiting herself through videos and things. And the Attorney General's opinion went through the analysis and pointed out several ambiguities in the statute, but in the end concluded that it's likely that Tennessee courts would say the trigger or the duty to report is triggered, and that this is the sexual abuse that's included. This case is not even close to that. It's actually much worse. And then you combine that, come on, Phil, y'all, why are you struggling with this simple thing so much? Well, you combine that with a DCS policy that says, the policy says, even if we had gotten this call, we wouldn't have done anything about it, potentially, except call law enforcement. Well, this is not the first time I've had a problem with the DCS policy, and it probably won't be the last. And so then you throw in all the HCDE policies and customs and practices And when it comes to children being abused, and particularly in this 605 incident, sexually abused is what I believe it is. DCS nor HCDE or anyone else can shirk their responsibilities to law enforcement entirely. So maybe it's time to change that policy, rewrite that policy, look at HCDE policies, but that doesn't change the law, and these are extraordinary facts and questions and jurisdictional and due process issues. One argument really wasn't made but could have been made is that the Sevier County juvenile judge, at least on December 24th, unrefuted testimony, had knowledge of something. Something was reported to the Sevier County juvenile judge on December 24th because testimony was that's when he signed the petitions. The petitions are for victim number 1. There are 3 more victims in this case. And so, that is an argument that could be made. That arguably the juvenile judge of Sevier County is the one, or also, like I said earlier, I have jurisdiction over these children because they live here, and that never changed during the course of these events. Also, the county in which the child is at present, jurisdiction lies with that juvenile court as well. Of course, at the 24th, I believe the testimony was victim number 1 was in Knoxville, but even so, that was reported. But there's no proof to me that the other 3 sexual assaults were reported. And let me say, I'm troubled with the testimony we heard from the detective from Sevier County on several different levels. And so then, the argument is, wasn't it reasonable what these 3 men did? And that is the argument. That is, the best argument. And nobody wants to be in your position and be judged in this regard, in this matter. And these facts are such that nobody, the victims, the families, the schools, the system, the citizens of Hamilton County, nobody, of course, anticipated or thought about this or wished this on anyone. But reasonable grounds is the only burden of proof that I have, that I'm asked to determine today. If this is a trial, I think my result might be different, and I think there are lots of arguments that can be made. But I just can't get around the fact that there are reasonable grounds for me to find that not just 1, but 3 victims were victims of sexual abuse. Somebody, the Court of Appeals, somebody may say, no, they're not victims of sexual abuse because the perpetrators were under 18. Well, let them say that. But the decision of the court is that there are reasonable grounds to believe and probable cause has been met that these are victims of sexual abuse. And even though, like I said, there's an argument that could be made that victim 1 was reported the next day, that's really not good enough. And there's no proof that the other 3 were reported. And so, based on those things, and with much thought and deliberation and concern over the whole nature of this case, let me just be clear. I'm concerned about these victims, that they continue to get whatever it is they need, and that's going to be different levels. The juveniles that committed these offenses are being handled in somewhere else, and they will get the either punishment or rehabilitation that's determined to be right for those offenses. I still can't undermine the seriousness of the situation for these three who, as I said, didn't follow the law in this case, but certainly are by no indication are terrible people and would have wished this on anyone. And another court may determine they acted completely reasonable or completely appropriate. That's not what I'm asked to do today. I'm asked to find whether there's reasonable or probable cause or not, and that's the ruling of the court. And so I'm going to bind these cases over to the 600 cases to the grand jury, and I assume the pleas are not guilty on the others, but I need to ask Mr. Davis as to your client, how does he plead on the 403 offense?
He pleads not guilty.
Mr. Houston?
Mr. Williams, not guilty, Your Honor.
And Mr. Bowe?
Mr. Montgomery is not guilty, Your Honor.
Then I will likewise bind those over to the grand jury. I'm going to set an OR bond. There's no indication. Mr. Pinkston, I'll hear from you before.
Fine with that, Your Honor. They just need to schedule a date and time at least to go through the booking process. They've not done that yet. The law requires it.
Your Honor, does it require that until they're indicted by the grand jury?
That's a good
It's
question.
a reasonable time after it's summoned. That they have to report and be booked in
All
accordance
right.
with sheriff's policies and guidelines.
Your Honor, the court has the discretion for these gentlemen not to be booked. All judges do.
Until after indictment.
I did totally disagree
All
with
right.
that, Judge.
Okay. Well,
Happens all the time, Your Honor.
that,
We all know that.
Mr. Pinkston, can you cite me some authority?
If you give me just a moment, I'll let me
Okay.
pull it up, Judge.
The risk you run is if they are indicted, they may be picked up and arrested at an inconvenient time, I believe. Is that a risk your clients are all willing to take?
Now, we will coordinate with this attorney's office the booking process.
Mr. Houston?
Well, I mean, if the DA is going to demand that these fellas basically go to jail and get fingerprinted after everything's been testified to today, this will do it. I think it's necessary.
The only reason that I say that, Judge, is simply because, as Mr. Houston pointed out, the general's not introduced any evidence that any of these men are flight risk or that they're dangerous people.
And that's the reason I said an OR bond. I will order that that coordination be set with or you all get with the district attorney's office and be booked within 30 days. That may be too long, but get with Mr. Pinkston's office and work that out and go be booked. And that way, I mean, I realize the repercussions, and that's a mugshot and all of that. But you won't be risked with being arrested at the most inopportune time. And, again, this case is not difficult. While I've got everyone else's attention, let me just say this: reporting child abuse, reporting sexual child abuse. Two things. Let me say two things. Senator Gardenhire, I trust that you and your colleagues will help give us some clarity on these matters from Nashville, or the Court of Criminal Appeals takes it up and gives us some clarity. But the main thing I would like to say is anybody who knows how to use Google or has Siri can just simply ask Siri, how do I report child abuse in Tennessee? And you get the 877 number. It's actually a human being. It actually works. I use it on the weekends or if I have to. I have used it before. the message, you know, the only good, the only is to get that message out that it's not difficult, it does work, and it protects children from future abuse and helps get protections in place for children. And it's not a difficult process. All right. Is there anything else the court needs to do in these matters today? Then counsel, thank you all for your strong argument and advocacy. Let this matter be concluded.
Okay.